understand what is summons. Summons means any proper officer, superintendent sir, can issue any notice under section 70 subsection 1 mandating the personal presence of any person, not only the person who has done GST evasion. No, it can be a chartered accountant also. If the proper officer, superintendent feels that I have any relevant information or knowledge about that GST evasion, about the clandestine removal, about that particular issue of invoices without actual supply of goods, all of those things. A CA can be called, a bank official can be called, a third party can be called, a witness can be called, a co-accused can be called, and the person who against whom investigation has been issued, he can be called. Please be ensured if you receive a summons notice, don't be startled. First see sir, as per the guidelines which we are going to discuss later, guideline, this is instruction number 3 2022-23 came out on 17th of August, which we are going to discuss later. It is mentioned whoever you are sending the summons to, you need to mention the role of that person, whether he's being called as a witness or he's been called as an accused. Otherwise, आपको कोई भी summons मिलेगा, आप बोलेगा मेरे against investigation हो गया. नहीं, you have to read a summons against whom the investigation is mentioned, against whom the investigation is initiated. If I have been called as a witness or as an accused or as a co-accused, right? So a superintendent, he can call any person for summons if he considers his attendance necessary on a given date and time mentioned in the summons notice to give evidence. Sir, क्या होता है summons क्या होता है? It is examination, interrogation. Officer is sitting here, the designated inspector. Usually superintendents, they are busy, so the inspector is sitting there. He has the computer screen. He has in format 40 questions. He's asking you, अच्छा sir, fake invoice था, आपका केस पकड़ा गया, आपका supplier जो है नोएडा में, he has been adjudged as a fake supplier. Means he is issuing just invoices. There is no actual movement of goods, and he has been कोई वहाँ पर investigation, inspection हुआ, and it has been adjudged he is a bogus supplier. जमा पर्ची का काम कर रहा है. So you have purchased from that supplier in this 1 year. So summons is issued because he is passing on input tax credit by just uploading the invoice in his GSTR1, but he is not actually giving the goods. There is no movement of goods. So you have purchased from him. You have just taken the benefit of input tax credit from the particular invoice in your GSTR2 and 2B. So sir, we want you to give us these replies to these questions. आप माल कब खरीदे, कितना माल खरीदे, कोई एजेंट था बीच में क्या, ब्रोकर था, and all those questions they ask you, right? You have to give statements, you have to give replies, and that can be admissible as an evidence in the court of law. Summons क्या है sir? Summons है कि आप वो रूम में जा रही है, but it will be considered as a judicial proceeding. आप कोर्ट के सामने खड़े हो, आप कटघरे में खड़े हुए हो, मतलब I'm just saying कटघरा नहीं है, आप चेयर टेबल ही है, but whatever statement which you are going to give has evidentiary value, can be admitted in the court of law. You can be prosecuted against that. Any other person can be prosecuted against that for the service of interest of justice. That can be admitted in the court of law, right? So these evidences, statements, documents, things which are mentioned, there are certain documents also mentioned in case if it is a fake supplier. So in the summons which we are going to see, document mentioned, oh please give us the accounts ledger with the supplier, please give us copies of purchase invoices. So we give that, we give our statements, and this is considered to be a judicial proceeding. Aap court mein baithe ho. And if you skip it, there are sections under Indian Penal Code which we are going to discuss, which you can be imprisoned also. So it's a serious affair. You are legally bound to attend summons. You are legally bound to attend summons and speak the truth. But apna safeguards kya hai? Let us discuss. We mentioned any person. Sir, if you are receiving a summons, is it 100% sure you have done GST evasion? अरे मेरे को कुछ पता ही नहीं है GST evasion क्या है. My supplier has done some fake invoicing for 50 clients of his. I am the 51st client. I have e-way bill, I have consignment note, I have all the bank transactions, I have every document factually available for substantiating the movement of goods from the supplier premises to my customer. I have all that. But since he has been adjudged as a bogus person, I have been summoned. Right? So any person can be summoned. I am not a part of the GST investigation. Investigation has not been issued against me, but I have been summoned. So because I contain certain facts for which they want to ascertain, they want to use those facts to corroborate the main evidence, to nip that kingpin person, right? That is one thing. There are Madras High Court judgment, Supreme Court judgment which I have mentioned here, that any person can be summoned. Please don't be, just be assured that only the person against whom investigation is issued, he can only be summoned. Sir, I said summons is a very serious affair, judicial proceeding. आप कोर्ट में बैठे हो. इसका मतलब क्या है? If you skip summons, if you don't attend summons, what is the outcome of that? Means there is section 193 and section 228 of Indian Penal Code. 193, what does it say? It says कोई भी झूठा फूटा आप कुछ भी चीज बोलेंगे, you fabricate any evidence, you can be in prison for up to 7 years with fine. hefty fines, hefty imprisonment. So it's a serious affair. Second thing, section 228 says if you do not cooperate, interrupt, insult any public servant or the particular superintendent or inspector, you can be imprisoned up to 6 months. If you don't attend summons, in the summons notice which we are going to see towards the end, it is mentioned section 174, 175 in all the summons, it is in the prescribed format. If you don't attend the summons, you will attract section 174, 175. क्या है 174, 175? 174 बोलता है if you don't attend summons without giving any reasonable explanation or adjournment or any reasonable justification and you skip it, so आपके अगेंस्ट में absconder का नोटिस निकाला जा सकता है. You can be imprisoned for up to 1 month with fine. Or if you do not submit documents which are mentioned in the summons, so you can again be penalized, imprisoned for 1 month. That is section 175. There is also you may have to pay up to 25,000 rupees under GST Act under section 122 subsection 3 clause D. Right? So attending summons is very important. Now significant aspects of summons. I have already mentioned the jurisdiction, who is the proper officer, superintendent is the proper officer. Right? DGGI can do that. Anti-evasion can do that. Pan-India body can do that. CGST counterpart can do it if you are registered under SGST or vice versa also. Now sir, as I mentioned, statements which are given during summons, whether they have evidentiary value, yes. Acha sir, we have seen so many Hindi movies, we see that the lawyer, hotshot lawyer in the courtroom, he says, acha, any confession given to any police officer is not admissible in the court of law. What does that mean? You've seen it in movies, all of us. That means there is Indian Evidence Act section 25, which is applicable on police officers. Means most of the 99% of the cases, police officers, they may use force, aggression, violence, and they may extract some involuntary statement or something which that person who is arrested, he will not say truthfully, he will say under coercion, he will say under duress. But similar nature is not that of our GST officers. GST officers are, as per law, legislators, they are going to not apply duress, coercion. So any statement given to a GST officer, custom officer, central excise officer is admissible in the court of law. Section 25 of Indian Evidence Act does not apply. Whereas practically on the ground, when we see all these, we are part of these investigation proceedings, so much of duress, threat of arrest, so much of stress of investigation, so much of threat for everything is there. That person has to make payment, that person has to oblige, has to make statements as per the will of the particular officer. Right? But out here it is clear, any statement given in summons can be admitted as an evidence in the court of law. There is Supreme Court judgment also in Rumesh Chandra Mehta. It is mentioned that custom officers, GST officers are not police officers. So section 25 of Indian Evidence Act is not applicable. Right? There are many Supreme Court case laws, other High Court case laws which I have also mentioned here. What we need to understand is there is a specific provision, section 136 clause B in GST Act. What does it say? आप कोई भी as a witness आप जा रहे हो, you given an evidence against the main accused. That particular statement which you have given, that can be used as an evidence in the court of law for the purpose of justice first, can be used to corroborate the main evidence and the other credible evidence in the investigation. And third is that it can be used for prosecution of the main accused. Now we need to understand whether the taxpayer has the right to remain silent. Sir, very important safeguard. We all should know this. We are expected to be truthful during our summon proceedings, examination, interrogation. If we have some data, we should give it. Otherwise, there are 7 years of imprisonment, up to 7 years. But sir, there is a settled law as per Supreme Court guidelines. Our Constitution of India, Article 20 sub Article 3 says, no person accused can be made or forced to be a witness against himself. So if you know something and you are the main accused, and if you feel that if you were to give this statement, which will be admitted as evidence, you have the right to remain silent also. You have the duty to be truthful, but you have a right to remain silent also. There are Supreme Court case laws in NSR Krishna Prasad and other PV Ramana Reddy Telangana High Court. Here it is mentioned, right to remain silent will not be assumed as an interference or objection during any proceedings. And it cannot be said as an obstruction, it is not an offense. Also, section 161 of CRPC, it says, no person is bound to answer any question which exposes him to a criminal charge. You know that if you are going to answer these particular questions, you are subjecting yourself to criminal charge. You be silent. They may say you are evasive, you are not cooperating. Oh, we will arrest you. But sir, there are again arrest provisions. You cannot just arrest me like that. There are lots of provisions which we are going to discuss. Right? Now, the right to remain silent we have understood. Let us see the law of retraction, sir. Very, very, very important tool, safeguard which we have during summons. Sir, during summons, I am shivering. I am confused. I am under duress, coercion. I have never been in a situation like this. So many questions are being asked to me, and I give a statement which is not interpreted properly, which is false, which I later on figure out that it is not entirely true. I am confused. I give wrong facts. So can I retract from that statement? Because that has become an evidence in the court of law. Yes, at the earliest instance that I realize that there is no time duration mentioned, maybe 1 month, maybe 5 days, maybe 10 days. You can write an affidavit, submit it to the proper officer, the department, anti-evasion department, DGG, and you can say, sir, I was confused that time under some whatever thing reason. Please replace that evidence with this new evidence of mine, and this should be read in this particular interpretation and manner. So you save yourself. This is law of retraction, very, very important tool. Okay. Now after that, we see, can a CA advocate a company? Sir, we are so scared of summons. We don't know what he will ask. We don't know whether he can arrest us from there. We don't know what type of law is around that. So our CA or lawyer, when we get a summon, 10 days notice is there, we need to reply. We prepare all the documents. The advocate or CA prepares us. These kind of sir, ये सब questions बोल सकते हैं, ये आपका case है, etc. and all. Still, I'm very scared. I'm walking upstairs to the anti-evasion or DGGI department. There, I have summons at this particular time. Can my CA or lawyer sit next to me, comfort me? Can he be a part of these examination proceedings? No, he cannot. As per law, settled Supreme Court guidelines also, that that this particular Supreme Court case law is the Poolpandi versus Superintendent. There is M.K. Kundia. There they say, sir, your CA or lawyer can sit at a visible distance, not at an audible distance. What does this mean? Visible distance. I am sitting across the glass and I am seeing there is no violation of any human right. There is no violent tactic. He is not being put under duress. I can see that, but I am not expected to hear the interrogation. I cannot intervene. I cannot guide or prompt. So, but in many cases, myself personally also, we request the proper officer who is the superintendent, and in many cases they allow the CA or the lawyer to sit next to the client during the interrogation. You don't interrupt, don't prompt anything. But it is a great mental support, right? So these are a few case laws which I mentioned here. Now, installation of CCTV. Sir, there is no CCTV or microphone facility. We've all seen, if we've gone to any GST department, anti-evasion wing or whatever, Supreme Court case law in Paramveer Singh, Saini and Baljeet Singh, very important safeguard. We can challenge the investigation, where they say that any room or any area of investigation, examination, interrogation, summon proceedings, there should be CCTV with microphone, so that the human rights, the particular rights of the person is safeguarded. They can record what is happening, that it is not under duress or coercion, right? This particular case law was also mentioned by the Karnataka High Court in Swiggy, bundle technologies, which we will discuss later. Very important case law. Now, very important, indispensable safeguard, law of cross-examination. Sir, very important. Even in income tax case laws, there are so many statutes it is there. Any third person, witness, co-accused, banker, your CA, any person gives any adverse statement or against me, submits any document and implicates me, say that sir, nahi yahi chori kiya. Now that person, the proper officer, has all this credible document in his file written, and he issues an arrest, or he issues a particular show cause notice, adjudication. So, can an order be passed without the opportunity of me cross-examining that person who is making an adverse remark against me, on the basis of which an order has been issued? So, Supreme Court in more than 20 case laws I mentioned here, extremely important, if you should always exercise the right to cross-examine. Now, there are Supreme Court case laws which have gone way beyond and said that if any order can be mentioned as null and void also, if it has based on an evidence which is a statement which is adverse in nature by a person against a person who summoned, and this person who summoned, he has not got the opportunity, or his opportunity to cross-examine has been denied. So that order can be null and void. You can file a writ petition. Also, this particular statement, it can be set aside and not be considered as an evidence if right to cross-examine has been not allotted, right? There are so many case laws I mentioned here. Also here, you can go through these. These are all Supreme Court and High Court case laws. It's a settled law, right? Now, right to refresh one's memory. Sir, I am sitting in summons. I will sit here for the next 8 hours. I will answer more than 100 questions. Am I expected to remember all the answers at that point in time? Or am I duty bound to answer all the questions? I have right to remain silent, we just understood, but am I duty bound to answer all the questions? Sir, I can say मेरे को याद नहीं है, इंसान है. We cannot refresh, we cannot have everything on our mind at right then. We can seek time. Sir, 10 दिन दीजिए. Give us 2 weeks, give us 1 week. We will come with the correct information and facts, and we will submit that under undertaking and cover letter. So I am not duty bound to give all the answers right then if I am not sure about the facts, if I am not sure about the 100% correctness of that. Also, we can refer to our tally data. We can refer to our books of accounts during summons. This is also another safeguard, because we are not expected to remember everything. Now, to-dos for if you are sitting in a summons proceedings, please do these things and don't do these things, okay, which I am going to mention. Please delve upon the facts. Sir, fake supplier का case है. Noida में जो supplier था, he has given me a proper bill, माल आया है, but he has been charged under fake supplier for other cases, for other clients. So I have all the documents. I give you bill, consignment note, undertaking, bank statement, I have delivery challan, I have bank statements, all of those things. And I am going to present that those are facts. Those are not matter of law. Please don't argue on matter of law. कि sir ये section का ये प्रावधान का मतलब ये है. No, leave that for your profession or yourself when you answer. Reply to the show cause notice which will be eventually issued. But only and only substantiate your genuineness of transaction or your case with matter of facts. Right? We are going to see walk through live summons and the replies and all. Please hire. You may consider to hire a professional who can guide you, who can arrange for these documents, who can train you or who can guide you as to what documents are required. Now here it is mentioned, don't give any additional document. हम लोग सुनते हैं ना GST department को एक ABCD भी ज़्यादा मत दीजिए, because they may just use that and they may use it against you. But in this case, if we are going to see, give additional documents if it substantiates your case. In the summons, only 2 documents have been mentioned. Supplier जो bogus supplier है, alleged bogus supplier, उनका सिर्फ invoices दीजिए and account ledger. But I have 10 more documents to substantiate my case. I will submit all of that. Why will I not submit? But don't submit any additional document which is irrelevant, which does not substantiate your case. Sir, you will not receive a copy of the evidence. They will print it out, you will sign it, before you will read it and then sign it. Please read it properly, because whatever you are saying, whatever he is understanding, whatever he is writing, whatever you are reading, those are 4 different things, maybe 4 different things. If you sign it, give it, you forget law of retraction, you're gone. This is admitted in the court of law. Please read it, then sign it. Also, you will not receive a copy. कोई copy नहीं है. Next show cause notice आएगा. So please, if there is any pending document detail which is required to be submitted after 10 days, 7 days, please write it down, because your memory is fresh then. Now, as I mentioned, instruction number 03/2022-23, dated your 17th of August 2022. These are guidelines for the issuance of summons, for summon proceedings, for transparency of these investigating authorities, for ease of business. So, what is important? Sir, summon should be issued as a last resort. ऐसे नहीं कि toffee chocolate की तरह बांट रहे summon 10,000. No. First issue a letter with a DIN asking for documents and details. If that person is evasive in his reply, does not give appropriate document, does not submit, does not reply, then issue summons. Guidelines are same. So issue summons only when it is required. Firstly, second, when you are issuing summons, do not use threatening language. Please do not use harsh language. Sir, section 174, 175 will be mentioned of IPC. If you don't attend summons, you may be imprisoned. If you don't submit these documents, you may be imprisoned. Those will be mentioned. But summons should not be in a threatening language. Second is, please do not issue summons to the top management. I am the owner of my business. My turnover is 1,000 crores. You are issuing summons to the director. Do I see tax affairs? Do I see accounting affairs? Do I have these day-to-day tax compliance knowledge? No, I don't have. Please issue summons, or the company will designate or will notify the department, sir, you can call these people, my accounts people, my finance people, they have the relevant knowledge. Please always summon only those people who have the relevant knowledge. Why are you wasting my time? Second thing is, even if you have to issue to the top management, it should be with reasons to believe that the top management is involved in any GST evasion case with any decision making. So if you have reason to believe, then you can ask the top management and you can in the first instance issue summons. Then there are Delhi High Court judgment, Jharkhand High Court judgment also here in GAIL gas and all that, whatever has been mentioned, this point which I mentioned. Summons should not be issued repeatedly. First letter, no reply, then issue summons. Take evidence during investigation, inspection, search, seizure, arrest. I get more evidence, I get more detail. I want to corroborate, I want someone to corroborate that I call the director again. Fine, but not on the same evidence again and again calling. No, that is not allowed. So DIN, it may sound so silly to us that the DGGI, anti-evasion, they are issuing notices, but they have issued 10 pages of documents. They have found all the approval from the assistant commissioner, deputy commissioner, everyone, but they have forgotten to put DIN. I will attach a particular notice which is not a summons notice. This has happened. This has happened for a very big casino client of ours in Gangtok. They have issued particular notice initiating investigation of 3 pages, 4 pages documents. No DIN is there. We challenged it. In this case, you don't even need to reply. The law says, but you should reply and should mention the particular reference of the circular, which is circular 122/41/2019. Extremely important safeguard. So you mention this, and that he cannot take any action. He has to drop that particular letter or investigation. Also, format of summons, there is a specified format which we are going to see as per the circular. Now there are other points which are to be. Sir, can you call for summons at 10 in the night, 3 in the morning? Sir, it happens. It is happening. Behind closed doors, when investigation is happening of search and seizure of big companies, this is what is happening. Doors are being shut. They have been asked to pay 5 crores, 10 crores, 20 crores, 50 crores, whatever. They are forced to make payment in the guise of voluntary payment under section 73(5), 74(5). But these are not voluntary payments. These are payment illegal collection. During investigation, we are going to discuss the legality of that. What is the, you can issue spot summons also, but ideally this should be the time. This time has not been mentioned in the law, not been mentioned in any guideline. This is as per a reference taken from Agarwal Foundries Private Limited, this particular Telangana High Court. Also, if you skip 3 summons, first summon issued today, second summon after reasonable interval of time 3 weeks later, 4 weeks later, there is no time limit, but reasonable interval of time. 3 summons skip, no reply, no adjournment notice, no request for adjournment, no seeking reasonable whatever. A complaint can be filed with the local magistrate, and an absconder notice can be, you can be termed as an absconder. Section 174, 172, 175 of IPC can be charged on you. So also, as I mentioned initially, if you remember, in the summons notice, ideally the name of the offender should be mentioned. If I am receiving it as a witness, I should not be startled to see that investigation has been initiated against me. Please mention the person, name of the person against whom the investigation is there, or my role for the summons. You have been invited as a witness.